Well, welcome to the second school law lecture. This time we're going to look at the general legal responsibilities a teacher has as she teaches in the American school. And if you have your test with you, just follow along because they're exactly in order. We're going to ask you a number of questions and see if you'd say yes or no to what you believe would be the answer. So let's see what we got. What do you think? Do teachers have to report suspected child abuse? That is, they have to. They're mandated. Answer is, what do you say? Answer is yes. Teachers have to report. They're mandated by state law to report physical, mental, emotional, sexual, and even neglect abuse of the children that sit in their classrooms. And they have to report. It's a mandated reporting because the law sees you as one of the last bastions of protecting children. And so if you willfully don't report what you suspect is a child abuse and something happens, you can be charged with a Class B misdemeanor. Now, you are provided with immunity from slander, from libel suits from the parents, because the parents typically are usually a little irritated that you called the SRS on them. So as long as there was no malice, you didn't do it just to get back at them knowing that there wasn't any, you're fully protected by Kansas state law. Can you be held liable for sexual harassment or bullying between students in your class? Just because they are bullying another, can you be held liable for it? Well, the answer to that too is yes. A teacher has to exercise reasonable care, what a reasonable, prudent person would do to prevent and correct when kids are harassing or bullying another student or even staff member. All your schools now, within the last 10 years, have updated their policy on harassment, bullying, sexual harassment, and there are grievance procedures now in place for all of our school systems. And in fact, probably if you've been teaching for over the last decade, you've had training to do these things. But you can be held liable if you don't follow policy from protecting staff. I remember when I taught in West Virginia, I was in charge of a mentor program, and we had a teacher in math at another school that I was overseeing, and he called one lunchtime and said, "Could you come over after school?" And I asked him, "Well, what for?" He said, "Well, I've got a meeting of parents, and I made a mistake." And he said he had a girl in class that was quite heavy, and the kids had been calling her, when she'd come into class, moo moo. And he had not said anything about it. But that had gone on for 3 or 4 days. And then when he was teaching the math lesson, he wanted students to put their problems on the board. When he looked at the girl to come up, he simply said, "Moo Moo, would you put up questions?" And boy, did the class respond with laughter. And he knew he'd made a mistake. And so I did come after school, met with the parents and principals with him. And, he apologized profusely, said it was his day, it would never happen again. And so he got by with that apology, but beginning teacher, he just didn't use good judgment in bringing that to stop. Can you be held liable for a student suicide? Now, that's a tough question. Answer is, by the court's precedents, yes. You must, again, report any oral or written verbalizations of suicide to school authorities. A lot of you English teachers will have kids write in a journal that about their daily feelings and the like, and typically there are no major things exposed. But if a kid does talk about suicide and you don't report it to a counselor, and then he does take his life, I can see where a parent would come back on you, especially if you found out about what he wrote in his journals and you didn't report it. Suicides tend to be, research tells us, contagious in schools, so we always seem to have several students that they put on suicide watch too when one occurs. But often suicide, when it does occur, that there be a team of counselors that will converge upon the school, and they handle those students very close to those kids, and in a very structured way. So you want to make sure that you watch out for those students that tend to express suicidal thoughts. Can schools be kept? Can they keep controlled substances out of the classroom? Well, that's a duh. Can't bring beer or any controlled substances into a classroom, so that's a yes. But what is a controlled substance? Cigarettes is rubbing, tobacco in the mouth. Almost all the schools have policies against all of those things. But if you have a kid that's arrested outside of school for a DUI or a drug or a alcohol arrest, can you expel them from school? And chances are the courts have ruled no, unless you have signed an extracurricular contract, like to play football. It could stipulate the actions that will be taken. Usually it's not expulsion, it's that you simply will not be kicked off the team. So we can, on extracurricular, control after school usage if you sign those extracurricular contracts. Can you test all your students for illegal drugs? That is, just to attend a public school, you'll be subject to random testing. Well, the answer to that is no. Right now, in our states, drug tests to attend a public school have not been supported by the courts. Now, they are supported, random drug testing for extracurricular kids. If you, in any extracurricular activity, almost all the states in Kansas sign a contract that stipulates such test will be given, and then they can take action as stipulated in that extracurricular contract. A student who brings a weapon on school grounds must be expelled for not less than a year. Well, that seems pretty logical. But answer is no. So let's talk about that one. The Gun-Free Schools Act and the Kansas statutes require boards of education to have a policy which expels a student for bringing a weapon to school for an entire school year. I mean, you expel the kid for an entire year. However, the superintendent may modify the expulsion on a case-to-case basis. That is, we have some ROTC programs that kids use guns in schools, but most of our schools don't have weapons on campus. A weapon can be considered a bomb, a silencer, or any device that's designed to expel a projectile at a velocity that would injure someone. But some weapons are excluded, like the military training use for ROTC, or a weapon safety course, or antique displays, or we have archery classes now and PE classes throughout Kansas and our public schools, and so those could be considered a deadly weapon. Hunting knives in the policy, sometimes boards may include a knife with a certain inch blade. But just because sometimes, here's a case when I was on the board. We had a young man who went hunting with his father on Sunday, and he simply put his gun in the back of his pickup truck on the floor, his cab, and had it encased, and he forgot to take it out and went to school and parked in the parking lot. Well, by definition, he has brought a gun on the school property. The officer found that when they were patrolling the parking lot, turned him in, and the principal expelled him for a entire year. Well, the parents kicked it up to the Board of Education, where then we listened to the lawyers, and my wife had the child in class. I knew the parents. I was convinced the child had no intention to shoot up at school. He simply made a stupid mistake with the gun in the back of his pickup truck. In fact, when I taught school in West Virginia, our kids back in the 70s would bring their guns on that were shown on the back rack of the truck, as long as they didn't bring it on school property. And so I was convinced kids shouldn't be punished ruining his career, and so I did not side with the superintendent, and 3 others of the board didn't either, and so he was reinstated, and it went on to finish high school, and then went on to attend our university and graduated. So it's handled on a case-by-case basis, but typically if you bring a gun on school property, it's going to be a bad ending for you. Can you strip search kids? You know, sometimes you think by the age of the kid, if you're a second grader or third grader, kindergarten kid, you can put their hand in their pockets to retrieve something. But again, it applies to all kids. No, schools cannot strip search a student, but you can search a student if there is just cause. And almost always now the policy require that the police officer located at that secondary school will do the search. And there has to be a reasonable suspicion that the student is hiding contraband or weapons, and typically it's a pat down. They're never going to be taking off clothes, but you can pat down a cause. You will never do that as a teacher. That will be done usually by the principal or the resource officer. Can you search a kid's locker? Well, answer is yes and no. Yes, if there's a just cause. Always in the past, sometimes we used to have locker clean out days, and you have kids clean out their lockers, and you could search the lockers, make sure that it was all clean, and those are kind of days that have gone past, because a kid has a reasonable expectation that this is his locker, and so you have to have just cause to open it and to search it. So that's why we use drug dogs in our public schools now. If they hit on a locker, it gives it just cause to open the locker, and almost all schools have a procedure. For example, most will. When I was on the board, our procedure was that if a drug dog hit upon a locker, sometimes they shared a locker, and if, let's say, drugs were found, then both kids would be brought to the office and separated, and their counselor or their school advocate, which is sometimes their homeroom teacher, would sit with them. Parents would be called. They would not be interviewed by civil authorities until the parent arrived. But the evidence that was gained in that locker if they didn't have a search warrant, it's really not admissible in court by law. But it can be used in school discipline. But we wanted the advocate to be with the child until the parent was notified and could arrive. Didn't want them to be interrogated by the police until they had a parent there. So there are certain stipulations. Now, not all policies are like that, but that gives them just cause to look in the locker and find things that maybe don't belong in a school. Can you keep their personal property if it is found on their possession, or they bring to class, like squirt guns or telephones or whatever that's bothering you? Well, the answer again is no. Of course, that's common sense. You can confiscate the property, like water guns or dirty magazines, but they should be returned. You should have a policy to return it, unless it's a dangerous weapon or a controlled substance or something illegal they shouldn't have. I always remember sometimes when I taught a long time ago, one time a kid brought a Playboy to school, and I was reading it. Can't believe it. Wow, I was giving the Shakespearean lecture, and saw him do that. So I confiscated his Playboy. He said, "Well, you can't keep that." And I said, "Okay, no, I'm not going to keep it. If you want it back, your parents will have to come in and get it." Well, do you think those parents came in to get their Playboy? No. But he claimed they had real good articles. So anyway, teachers can confiscate things, but they have to give it back typically, or have a policy to give it back. Can a teacher use corporal punishment on a child in Kansas? That is, can you spank him? Well, no. Not a teacher, but we are one of the few states in America that does allow corporal punishment on a child. It's typically recognized by the courts as actions that cause physical or emotional harm and fall under the legal terms of assault, which is a fear of being hurt, and battery, which is unpermitted touching. So it could be considered spanking, or if you slap a kid, paddle a kid. It's sometimes even in the courts have fallen under putting a kid in the closet, putting their nose in a circle, or other humiliation that you make the kid feel ridiculed in front of students. It has even fallen in a academic class where you make kids do exercises as discipline, not in a PE class, but if you make a kid drop and give you 10 while you're teaching, that has fallen under doing emotional harm to kids. So an unfair punishment. But Kansas does allow corporal punishment, but 3 guidelines in the state statutes must be followed if you're going to spank a child. First, it has to be done by the administration, so you as a teacher will never spank a child. And that second, there's a timely notice. It has to be sent out in the school rules at the beginning of the year. This is what your child will be spanked for, blah, blah, blah. And then second, you have to send written notice to the parent that they have due process before the child is to be spanked, and allowance for a hearing before he's to be spanked. Well, that's going to take, by certified letter, another week, and then it has to be reasonable and witnessed by somebody. So very few principals anymore will spank a kid if those 3 things by law are met. We just don't do it. Can you reduce kids' grades to discipline students? If you don't start behaving, I'm cutting 10 points off that last quiz. Well, why do you think the courts decided? Answer is no. Unless a written grading system is provided to students at the beginning, the syllabus, or at the beginning of the year, and the parents are aware of it, that there are reductions for the grade for bad behavior or discipline things, the grade really can't be reduced. But many teachers have put this in their syllabus, especially in PE and the like. If you don't abide by these rules, this could happen. So you can still do that, but you have to notify them at the beginning of your syllabus or at the beginning to parents' letters home. But the courts generally have not supported teachers who give extra homework as punishment. That is, if a class is acting up and you say, okay, you guys want to act like this, I'm going to give you 10 more problems. They tend to look negatively on that, because what do kids learn if you use homework as punishment? You learn that it is punishment. Or you use exercise as punishment if it's a non-PE class. That is, making an English kid drop down and give you 10 if he didn't do something right. In coaching, we use exercise sometimes if you don't do things right, or for example, as a basketball coach, I'd have stop practice, and if a kid, I would send the kid to the foul line. If he made those 2 free throws, we'd quit running. If he missed them, we'd run again. Well, what I'm trying to build is camaraderie, that we're all in this together, that there is stress on making free throws, and you got to get it done. Well, at least in coaching, there's a reason for it. But in an academic class, there is not. Can you punish the entire class for the actions of one? Well, the courts have not smiled on that either, neither have principals. If one kid acts up, and even if you don't know who it is, you shouldn't punish the entire class for that. And definitely the law, you cannot punish special ed children because of their handicap by Public Law 94-142. So you need to know what the IEPs are, especially for your BD students, because they will have a specific plan of action for you to follow when a kid misbehaves with a BDI plan. Can a student's earned credit be denied for poor attendance? For example, if you miss more than 8 days unexcused, it doesn't matter what you make in that class, you will not get credit for the class. Popular policy in the secondary schools in the Midwest, well, have the courts found that to be a viable policy? Answer is no. In 1980, in a court case, a district court found that this school district that had 6 absences in a 9-week period led to a loss of credit. It was arbitrary and capricious. The present general view is that any grade reduction due to unexcused absences should only reflect the actual impact of the absence on the school's academic performance. And so basically, unless you had it in your syllabus that attendance is a big part of this, you can't reduce the kid's grade. Grades reflect academic achievement, not seat time. For example, in the school that my daughter went to, which was I was on the board, if you were 15 minutes late to a class, you were counted as absent. Not tardy, but absent. And so let's say I was a dad that just couldn't get his daughter there all the time to class on time at the beginning of the school year, or at the beginning of school. And so my daughter in first period was absent 9 times, more than 20 minutes. And she was counted absence in 9 times, and the policy was you lose credit after 6. My daughter could have been in that class every day. She could have gotten 100% on everything she did in that class, but the policy says if she had 6 absences in a 9-week period, she would lose her credit. Well, that's just wouldn't stand in the court system in camp today. So any parent that knows what the law is, the school district will have to back down. Can a non-custodial parent see their child's permanent records? Now, non-custodial parent is decided by the court system, and sometimes you parents don't, or you teachers don't know who the non-custodial parent is in the secondary school because you have so many students. But in elementary, you typically know that in a divorce situation which parent has custody. But a non-custodial parent cannot see their permanent records by the Buckley Amendment. But if a parent does ask, a custodial parent does ask for your child's permanent record card, you have to produce it within 45 days. A student can request a hearing on any documents in that file. You can not release any identifiable information without permission. And that's come into play with transgender kids here recently. But a custodial parent can sign for the release of information to a non-custodial parent. So a non-custodial could see it if the custodial parent releases it. And the parents have the rights until the student is 18, then it becomes his right. And for example, with all of you listening to this, I cannot talk to your parents about how you're doing in this class unless you waive that right. And in fact, when you want to have me write a recommendation for you to put in your payment file, you will waive that right of access to record when you apply for that school district. They have a little thing for you to sign. So Buckley Amendment is a big one for privacy of information. Can you administer first aid? Well, answer is, it sounds kind of common sense. If I have a headache, couldn't you give me an aspirin? Answer is yes, but you can only perform first aid as necessary to save a life. That is a Heimlich maneuver for choking or whatever, to stop the bleeding, a tourniquet. If it's non-life threatening, you have to follow the school policy in seeking medical help, notifying the parent, and completing the accident report. That is, you can't give kids their medicine. You have to actually get the school nurse or medical help for them before you try to do anything that's non-life threatening for that kid. And I would always advise all of you to buy some packages of gloves that when a kid starts bleeding or throws up, you don't touch it. If it's wet and not yours, don't touch it. You almost have to assume that every kid through his blood or bodily fluids will have some sort of disease that you can catch. You're much wiser to do it that way. So I'd keep some gloves in there, especially if you're a coach and your trainer's not present. You do have two heads, butt, and they bleed like a stick pig if you hit above the forehead, and you have to kind of stop that bleeding till you get medical help there. Somehow I'd always have some gloves with me. Can a teacher give medication to kids? Answer is no. You can't give any medication to kids, not even aspirin. The school policy will provide for the school nurse or that designee to hold and dispense all school student medications, and there has to be 3 guidelines. You have to give written parental permission to do it, to give them medication. You have to have the prescriptions bottle with you, and it has to be given by the school nurse or that designee. We had a case where a parent wrote a handwritten note, said, give Sarah 3 pills every hour, and she put the pills in a little plastic case with that note. And so the teacher then gave the 3 pills to the little kid every hour, and then till he just kind of fell over his chair and went comatose. Um, well, what had the parent done? Instead of 3 pills every hour, it should have been 1 pill every 3 hours. And so, how do you think, even though it was the parent's fault, did the teacher follow what she should have done? Was there written parental permission? Well, yes, but was it in the doctor's prescription bottle? No. Was it given by a designee or a school nurse? No. The parent can't override what the doctor said to give the child. You have to follow what's on the prescription. So, no, just don't give any kids any medication. Can you be sued for talking about students? That is, you go to the hairdresser and you talk about how Bobby got involved with 4 of the cheerleaders, and now there's a squabble between those 4 girls, blah, blah, blah. Can you talk about other kids? Well, yes, you can, but you can be sued for making oral or written false statements that maybe were untrue. It's called slander if it's a false statement that you say, and if libel if it's a written statement that slanders another's character. You can't tell a kid has a bad disease or they're undergoing a sexual transformation. You can't claim a student is sexually active or doing immoral things. You can't disparage a kid's competency. Oh, this kid's as dumb as a doornail because he blah, blah, blah. And one of the biggest things to get you fired is using racist remarks about a kid. That will get you almost every time. Can teachers get in legal trouble for allowing students to pass back graded papers? Well, yeah, it did happen in Oklahoma. Not very often are you going to get in legal trouble for this unless you just don't use some common sense. But basically the answer is yes. Since student grades are considered privileged information, teachers can be sued for allowing students to pass back papers, grade other kids' papers, and posting papers or grades where all the kids can see what all the kids got. If a parent asks you to stop doing that, or a child stops that, if you're doing it, then I would definitely stop, because your task is not to embarrass a kid. And if kids are passing back papers and say, "Hey, Bobby, you flunked again. Good job," it just is not a good situation for your class, and a parent has a good right to get on you. Is a signed written permission required for a teacher to take a student on a field trip? Well, yes. The key to a good field trip is notifying the parents, and it should include 4 things: the date, time, location, and how you're going to get them there. Second, the rules of conduct for the field trip. And then third, a statement that absolves the teacher from liability, and that's by what the lawyers say is not worth a dime. It does not protect you from a suit of negligence. They can't waive their right to sue you for negligence. So, no. And then a place for parental signatures. And that's always a tough one, because I know when my child left for K-State, going to college, we found in his drawer, when we cleaned out his student desk downstairs, where he practiced my signature about 25 times. It was just as good as my signature. So I have no idea what I signed my kid out for there in that year. Hopefully your child's not like that. But the second thing, a telephone call should not take the place of a written permission, because you don't know who's calling. Ferris Bueller made that pretty funny on that one, but you just can't call in and say, the parent can't ask could we take him home? You should have written permission for that to occur. When you do take a field trip, you ought to have adequate number of adult supervisors. You don't want to take a kindergarten class to a steel mill with only one teacher. Just not what a reasonable, prudent person to do. And then when you're going to transport kids, you only want to use the school vehicles, not your own. That is, if you are a golf coach and you have to take your 6 golfers, take them in the school van, not your own car, because the liabilities on these things are different. And for whatever you do, as we mentioned before, you are liable anytime you send a kid on an errand off school grounds. So I just never would do that. Can a kid play, or can schools allow girls to try out for a boys' team? Excuse me. If the sport is not offered for the girls. Well, that's a logical one, but by Title IX came down as a yes. No person shall be denied on the basis of sex to be excluded from participation in or be denied benefits of or be subject to discrimination under any educational program or activity receiving federal financial assistance. So if you're a public school, you've got to allow a girl to try out for the wrestling team or the football team if they don't have a wrestling team or a football team. And the schools have to pay coaches, the male coaches, just as much as the female coaches. And the schools cannot provide unequal funds for girls and boys sports. So, and that's one of the tough ones for an athletic director to follow. That's Title IX. Does a student have the right to keep their transgender status at school private? Well, this is pretty recent, within the last 10 years. And the answer right now is yes. Transgender is an umbrella term that we use to describe a person whose gender identity or gender expression is different from that traditionally associated with the assigned sex at birth. And so a student can be asked and should be addressed by the preferred name and the pronoun that correspond to the student's gender identity. Now, in transgender and gender nonconforming students, they should be permitted to dress in a manner consistent with their gender identity. And there's some stipulations in that, but they should have access to restrooms and locker rooms that correspond to their gender identity consistently asserted by the school. And if they need to have or desire increased privacy, should be a private access to a single stall restroom or changing area. And it's a very touchy subject, but right now that's where it stands. It may change, but here's even as we look at the Secondary Schools Activities Commission, here's an even touchier one. Can a transgender student play on a team opposite their birth gender? Well, the answer so far is yes. The school is responsible for determining the appropriate gender team for the participation by the transgender student, and they in the State Board of Education's decision, they gave some considerations to follow. The gender identity used for the student records, the medical documentation such as the length of the hormonal treatments, the sexual reassignment surgery, the psychological counseling they've gotten, how far along they are on that, and the related competitive advantage. And so right now the policy is the school must notify the Kansas Association Secondary Schools prior to entering the student in the eligibility system and allowing participation. The school board, Kansas Secondary Schools Activity Commission, will make the final ruling on the student's participation in the event of a dispute. So they're not going to challenge the school's ruling unless another team says it's given them a more competitive advantage and there's a dispute. So we'll see if this changes as we get more into that issue. Can a school homeschool child participate in a local high school's football program? What do you think? If he doesn't even attend anything at that school? Answer is no. But yes, right now the Secondary Schools Activities Commission has eligibility requirements for students participating in activities. They must pass and be enrolled in a certain amount of classes. Well, if the kid is in a homeschool program that is accredited by the state of Kansas and is passing the needed number of courses, he can play. But if he's not, he can participate in the football practice or the band practice or whatever, but he just can't perform when they go in a secondary school sponsored activity. So kind of touchy there, but we'll see how it changes. Can parents exempt their children from going to school? Well, again, the answer is yes, if you're over 16. That is, the laws in Kansas compel a student to attend till they're 18. Then he can make that decision himself. Or he has to attend an equivalent, either private or homeschool. He has to attend something till he's 18. Or the parent waives his right to drop out of school if he's 16. In Kansas, a principal has to report homeschooled students to the SRS or county attorney, and after they investigate, if it is felt the child is not receiving a quality home education, it is reported to the court for their decision. So a parent just can't say that he's educating his kid at home. He has to have some sort of program that's working with the kid. And a kid at 16 can drop out of school with parental permission from the parent. Can a student's voice, can they voice religious or political opinions in class? That the president is crazy, or the House of Delegates just got this wrong? Well, yes, as long as it does not cause disruptions. The Tinker versus Des Moines in 1969 case ruled that students do not lose their rights of freedom of expression when they enter the schoolhouse doors. So students have the right to be quiet during the Pledge of Allegiance. They can wear religious symbols or clothing. They can pass out religious materials. They can criticize school officials and underground newspapers, as long as it does not cause a disruption. A lot of times, if you have a white supremacist group or KKK that want to form a club, it's got past history that will show it could form a disruption in the school, and it's usually cited with the courts that they wouldn't allow that to occur. So that causing a disruption can be the key. Can you, as a teacher, teach creationism if you firmly believe in that theory? Well, you're a teacher, should be able to teach what you believe. Answer, however, is no. Your job by contract is to teach the approved curriculum. Now, if the district has approved the religious theory of creationism as what to teach, then you have to teach that in the place of Darwinism. But right now in the state of Kansas, it is not the theory being taught, but any biology teacher will tell you that once you teach Darwinism, you probably have a discussion on creationism, and that's fine. You want to have that discussion. You just can't teach it as the approved curriculum. And we had a big fuss over that about 10 years ago. It, for 1 year, was in the curriculum, creationism was, and then it was taken out by the State Board of Education. Can a student pray in class? Well, I did quite a lot of times right before a test. Sometimes it didn't help much, but yes, a student can pray as long as it does not cause a disruption. You, as a teacher and as a school, must remain neutral in the matters of religion. We cannot, as a school, offer a religious class that offers a certain belief system. We can't have an opening voluntary prayer or a Bible reading. We can't really pray at school activities as a sponsored prayer. We can't allow a coach to lead the team in a prayer before the game. We can't restrict the number of absences for religious holidays in certain religions. We cannot pass out Bibles, but students can. But a student or a school can study the Bible as religion, as a history book. We can allow religious clubs to meet. In fact, I help sponsor student Christian athletics group. We can invite religious speakers as long as a parent can excuse their child. So it's kind of a touchy issue, but the schools just have to remain neutral when you talk about prayer. Now, do coaches, one of the questions always comes up, well, teams pray before they go out in the field all the time. Yeah, my team did, but we had a student or we had a minister lead the prayer. I can't as a school employee, but as long as somebody else did, and I couldn't force every kid to do it, but they did because we were in a very conservative area. As long as somebody else led the prayer before the game, that was fine. Can we celebrate Christmas in class? Well, of course, yes. Now, you music teachers always say, well, how much religious music can I play at one of our programs? Well, as long as you mix the religious and, well, secular tunes, nobody's typically going to complain. What we can have are usually the nativity scene or any plays portraying the Hanukkah miracle, usually will get criticized. As long as you don't favor a certain religion and mix the secular as well as the religious music selections, you're fine. Can teachers have students read materials with cuss words? Being an English teacher, I went through the Kanawha County Textbook Association, which, if you read about the history of censorship in America, that was a big one in Charleston, West Virginia. But typically, though the parents may exempt their child from reading certain works like the Crucible and some of the Shakespearean works, or even the Canterbury Tales, some of the tales there, they're classics, but they have some, if you could understand them, some dirty parts, controversial parts. As long as you can show them to be relative and it fits the maturity level of the students, and it's not going to cause a disruption, you can usually cover those. Again, it depends on those variables. You know, first graders are different than 12th graders, so just be careful of what you have kids read. As long as it's thoughtful and scholarly and mind-provoking, typically the school system will side with you. Can you use the internet material in your classes? And we've got quite a lot of rules on that, and they're kind of long for me to go through, but basically you can use as the things from the web, the videotapes that you've purchased or rented, or music that you're only going to use one time for educational purposes. You can't however, run off a textbook. You can't afford to buy the textbook, so you just duplicate it That's going to get you in trouble. But unless you're trying to make money off of it or cut expenses, probably you're not going to see anybody coming after you in using that. So you can use the internet, most of the internet, unless it says it's highly copyrighted. And we're seeing the internet explode with lesson plans and videos and music and material that you can use in your class that's not copyrighted. So unless you're going to try to make money, off of it, you're not going to get in trouble. Do schools have to teach in their child's native language? Well, of course, if we had to do that, you might have 11 or 12 languages spoken in your school district, and there's just no way. But by the Bilingual Act in 1988, you must provide bilingual education for children with limited speaking ability. So we have to teach them English, and make an attempt to teach them English as they go through our school systems, but you do not have to teach in their native languages. If you have a student with a special learning problem, do you have to provide that special learning program? We call them IEPs, to fit their needs. And of course, by Public Law 94-142 and IDEA, yes, you do. And I'm sure you've had classes on this, but basically, it's the duty of the school to identify those students, and each student has to have an IEP or an individualized educational plan, and you got to follow that. And right now, since the 1990s, each student must be in the least restrictive environment. That is what best suits his program of development, and that's decided in the IEP meeting. So you've got to know what it is and to follow that. And you can't punish a kid for his disability. So know what that disability is and follow what the IEP says to do for them. Can schools require teachers to individualize their class material for special children? Well, of course. Yes, they can. We call them modifications or accommodations. Those are usually spelled out by the IEP or by your common sense. And can students separate students according to race, put them in separate classes? Well, the answer, of course, came out of Brown versus Board of Topeka here in Kansas in 1955. And then other court cases define segregation in different ways too. But the answer is no, you cannot do that. Can a superintendent hire a teacher? Well, a lot of you missed this one. The answer is no. He has no power to hire you. The Board of Education is the only one in an open meeting that can hire a teacher. And really, you're not hired until the minutes of the next meeting are seconded, and it becomes in the minutes. But a superintendent at 99.9% of the time has control of the board. And when he says he's going to offer you a contract, go before the board. You're going to get that. But there's no use to argue about your contract because they are negotiated in the state of Kansas, and it's going to outline your rights, your employment, your salary. And they may ask you to accept some supplemental assignments like coaching or cheerleading, ticket taking. And you can negotiate that. No, I don't want to do that, or yes, but those also have certain salary schedules and like that you're probably not going to be able to negotiate. So just know that until the Board of Education meets, you're not really hired. Can a teacher's certification be revoked for taking another job or signing a contract? Well, let's figure out what that one means. Well, yes. If you sign a contract and take another job, or even verbally tell them that you're going to take the job, and then you decide you want to go to another school district and you sign their contract and you take their job, and then call the other one and say, I'm not going to take yours, I took this one. Well, that Board of Education that you said no to can charge you for the cost of the replacement and petition the state to withdraw your certification. Now, never known for it to be done, but it's just not very professional to sign two contracts, because principals talk and superintendents talk, and they have a good contact system, and so that could blackball you for that state if you do something like that. So just know that once you say you're going to take a job, follow through with it. What is tenure? Well, the Kansas changed that in 2014, and they passed legislation to eliminate tenure. And tenure is basically after 3 years you get tenure, and if means that they have to offer you due process and give you a reason and a hearing if they're going to try to terminate you after 3 years. In Missouri, I think it's 5. But the bill really didn't do away with eliminate tenure in Kansas, because most of the school systems kept that policy in their negotiation agreement. And so though they may not call it tenure, after 3 years they would give you a continuing contract, and then they'd have to give you a reason for you not coming back the next year, and that gives you something to fight and a process to go through to fight it. So collective bargaining in Kansas can change what the legislature wanted on eliminating tenure altogether. Can a tenured teacher be dismissed without a reason? Well, as we just mentioned, the answer is no. You can be dismissed for almost anything that the board wishes to, but the ones that have upheld, they fall under 5 categories: incompetence, insubordination, immorality, negligence, and economic reasons. We call it rifting. That is, if you are just incompetent, and it can't be just one incident. It's a series of documented incidences, and they've usually given you opportunity to improve, but it's lack of knowledge, or you can't control your kids, or you misspell a lot of words that go out, or complaints from parents, or low evaluations. That's all incompetence. Insubordination, if you can't abide by reasonable rules, like you're tardy all the time, you're not attending the PTA and they want you to, you're not counting tardies, or it used to be, if sometimes they dismiss one for not residing in the district, and that one really, I think the courts sided more with the teacher on that one. But you can be dismissed for immorality, for adultery, or even in the past, homosexuality, an unmarried pregnancy, drunkenness. Now, that's not means that it's not going to occur in every district. These are just things that teachers have been dismissed before, and usually the very conservative school district. But definitely the things that under this, like inappropriate discussions with students, love letters to them, that's going to get you every time. Allowing a student to drink at your home, those will get you fired. So under immorality. And then negligence, you just don't act as a reasonable, prudent person. If you lose a lawsuit against a parent, they'll probably terminate you. And then sometimes, because of decline in student enrollments, they call it rifting. Even though you're tenured, if you just don't need that many teachers, or they abolish the position, they can riff you. But basically it has to be a pattern of misbehavior, not a single incident or 1 or 2 incidents. It has to be a pattern. So tenure is a good thing for teachers, because coaches sometimes will make a parent mad, and just because you don't play a kid for a certain amount of time, parent feels like, I'm going to get you fired. Well, they can't really do that if you're tenured. Can an untenured teacher be dismissed without reason? Well, the answer, as we've talked about, is yes, because they get simply a contract every year in the mail, They have no due process rights, and basically you just don't get the contract in the mail to sign for the next year. So they don't have to give you a reason. They just don't. Well, they usually tell you that you're not going to get a contract, but they don't have to give you a reason. And if you ask for one, they will not give you one. Can you be dismissed for promoting a political candidate in class? Well, yes, if that's what you promote, and you are biased that way, and teach it. But generally speaking, teachers who, when they're asked who they're supporting, they can speak freely about their preference. But you just can't preach it as a promotion in your class. You have to be impartial. Can you wear political buttons and circulate petitions on grounds? Well, yes, because you as a teacher don't lose your rights as you enter the schoolhouse door. But you have to be smart here. You can voice your safety issue concerns or violations of policy. You can criticize school policy as long as it does not cause a disruption or disclose confidential information or attack someone. And those are all touchy issues. But you have a right to voice your opinion, but you've got to be careful in schools because they typically hold teachers at a higher standard than they do anybody else. Can you take several months off to care for an unborn child? Do you have those rights, either a male or a female? Well, the answer is yes. You can take up to 12 months to take care of your child. It's unpaid, but your job is protected to care for a newborn or an adopted child or even a sick family member, but you're just not paid. And that's for a male or a female. And can you dress as you like? Can you wear whatever you want to school? Well, answer to this one is no, because these are, again, negotiated agreements with your school board. They can regulate appropriate dress unless it reflects a teacher's racial or ethnic belief. But they can regulate dress. Can they force you to wear a tie every day? Well, yes, if it's in the negotiated agreement, yes. But most don't. So just know that they can regulate dress. So what have we learned about teaching? I didn't give you this lecture to scare the death out of you, but the more you know what you can and cannot do, the less afraid of the law you're going to be. The law usually is on your side. And I'll guarantee you're going to be threatened by a parent over the next couple of decades to be sued. But once they realize what they're fighting, it probably doesn't come to fruition. So you're probably not. Just know what's right and what's wrong. And evidently, my video doesn't work. So I hope you got something from the school law lecture. Know it's your friend, and hope you did well on the test. Thanks for listening. Bye-bye.